any other issues, we can work our way around that as we go ahead with the program. Okay, so I'd like to welcome everybody to IGSA's first event for this semester, and I'm very pleased to have you. I think so far we have about 25 people or 24 people with us, and we are still expecting more. I hope you would have close to 50 by the time we are done, hopefully. But it is very important that international students get together and talk about issues that are very necessary to us. And one of those issues is immigration. As we all know, we are immigrants in this country, and especially as the country prepares for another elections in a few weeks, it is very important for us to have discussions regarding our status in this country and regarding any other changes that could affect our stay or our status in this country. So I thank our speaker for agreeing to speak with us today, and I thank you all for being here. I'll call on the Vice President, Ainura, to introduce the speaker when I'm done. But before I do that, I would like to lay the ground rules for today's meeting. First of all, I would just encourage all of us to mute our microphones, especially, so that we do not interrupt the speaker whilst he is doing the presentation. I wanted us to also turn off our videos, but upon the speaker's request, if you are able to leave your video on through the presentation, please do that so that he can see your facial reactions, and I think it helps him to deliver better to us. The second thing I'd like to let you know is that the speaker has requested not to take questions while he is presenting. He would like to take all the questions after he's done with his presentation. So if you have any questions at any point in time during his presentation, just go to the chat box. It is open, so you can head to the chat box, type in your question, and we have our team putting together all your questions with your name. And after he's done with the presentation, they will put your question to him, and he will surely answer your question. Once the presentation is over, the member of our team who has the questions will put the questions to the speaker and he will address them. But at that point in time, if you also have a question that you would like to ask, at that point in time when he's done, you can raise your hands in Zoom and we will call you for you to ask your question. At that point, you can unmute your microphone and turn on your video at your own discretion, because the presentation would be over. So at this point, we are not taking questions, but when the presentation is done, you can turn on your video and directly ask the speaker your question, or you can type your video right now as he's speaking so that we take note of your question and put it to him after he's done. So at this point, I'd like to call on Ainura, who is the Vice President for IGSA, to talk about IGSA briefly and introduce the speaker. Thank you.
Thank you, Max. Hello, everyone. Can you hear me? Yeah, just we'll have a couple.
Yes.
Okay, good. My name is Ainur Kenjetaeva, and I'm a PhD student in Political Science Department at Kent State University, and I'm a Vice President of International Graduate Student Association that organized this great event. And our president is Maxwell Ajay, who also a PhD student and PhD candidate actually in Kent State University in the same department, political science. And tonight, thank you for that you organized this great event and invited such a knowledgeable speaker, attorney, Mr. Farhad Setna. And I will tell you a little bit about Farhad Setna. So he's actually, as I said, an attorney in immigration law, and he's practicing law since 1991. And actually, he has BA. He has MBA in International Business and Marketing, and he has a JD in University of Akron School of Law. Also, he is a member of 2 bar associations in Akron Bar Association and Ohio Bar Association. And maybe also Mr. Farhad Setna also want to say something a little bit about yourself too.
I do appreciate the chance to be here, Max and Ainur. I'm very grateful to be here. I'm very happy to be here. Can you hear me clearly?
Yes.
Wonderful. I'll let you continue, please, Ainur. because I'll be talking a lot this evening.
Okay. Actually, one also I can add something, some another things about Mr. Setna, that as I said, from 1991 he's practicing law, and he actually started in Akron, a law firm, and in 1996 he started his own practice. So also moved from Akron to Cuyahoga Falls. And also, Mr. Setna is an adjunct professor in the Akron University, the School of Law. I also actually has a master's degree from University of Akron, so it's a great university. Yes, and I know that you also have a license of a pilot, right?
That's right.
Yeah, that's very interesting. So you have many other different
Hobbies.
interests, yeah, and knowledges. Okay. So maybe, yeah, you want to add something else about yourself? Something that I didn't
So
Started.
I think his experience is very extensive, and one thing I'd like to say is also he came here to the US as an international student, like most of us, and so that helps him to be in a position where he can greatly advise us and counsel us as we go forward in this endeavor. So I think you've really introduced him well. So at this point, you just leave the platform to him for him to start the presentation. Thank you very much.
Thank you.
Thank you for having me. And Max, I just wanted to ask you, would you start the recording, please?
Yeah, it's being recorded.
Awesome. Thank you so much, sir. I appreciate that. Well, everybody, good evening to you. My name's Farhad Setna. Ainur, thank you for that very nice introduction. I really appreciate that. Thank you so much. Max and Ainur, I can see your faces. Can you hear me clearly?
Yes, I can hear you and I can see you.
Good, good, good. Okay, so what we're going to talk about today is the basics of immigration to the United States through employment. Now, all of you are here. I know many of you are foreign students. Many of you are grad students, most likely. That's what Max told me earlier when we were discussing a possible audience that we were going to have this evening. And my goal is to give you a basic overview of immigration to the US through employment. As a little bit of a background, I teach immigration law. I've taught immigration law at Akron Law for over 25 years now. I've written the textbook that I use for my class, and I've had many, many thousands of clients over the last 25 years, as you can imagine. They're clients for business, they're clients for naturalization, which is citizenship, they're clients for immigration, for families, for husbands, for wives, for children. They're clients for people who are facing deportation, who may be, who the US government is trying to remove from the United States. So I've had many, many different types of clients, different fields of law, of immigration law. And of course, I've also practiced extensively in the area of asylum law, or refugee law. Now in Ohio, we have only one court for immigration, that's in Cleveland. We've got a number of immigration offices. The main office for Ohio is in Cleveland. There's a sub office in Columbus, Ohio, where I was just last week on a case, and another sub office in Cincinnati, Ohio. So we've got 3 USCIS offices in Ohio and only one immigration court in Ohio located in Cleveland. So with that sort of background, let's jump into basics of US immigration through employment. And I'd like you all to send your questions by chat to Max or to Ainura, and then they can distill those questions down and they will ask me those questions at the end of my presentation. I hope to present for about 1 hour, ending at 7 o'clock, and then we'll have about 30 minutes for questions and answers. So without further ado, let's get the ball rolling. Now, this is only a general presentation. As I tell my students, even in my immigration law class, immigration is so detailed, I can't give you specific advice on your specific case. If you have questions on your case, consult a qualified attorney. Please don't take what I'm saying here as being specific to your case. I can't exhaust every option on every case in this brief presentation. Keep your questions and answers for the end, and Max and Ainura will definitely feed me those questions. So what are some of the immigration, employment-based immigration types of visas? We've got a number of visas in the non-immigrant category. We're going to talk also about immigrant visas, which is the long-term or green card to stay in the United States. We're going to talk about steps in the immigrant visa processes, how you get your green card and so on. And then of course, naturalization at the very end. So this is all geared toward immigration, both non-immigrant and immigrant, through employment. So first thing I want to ask you and make sure what we're going to cover today is the following. We're going to cover the basics, maintaining your status as a student, what happens to families and dependents, non-immigrant to immigrant status, H-1B, and new registration requirements, which are constantly coming out under this administration, which you probably have read about, other work authorized non-immigrant visa options, immigrant visas through the PERM process, EB-1, 2, and 3. Other immigration topics we'll also cover, but very, very briefly. The typical routes to immigration are immediate relatives, family-based cases, employment, asylum, as I mentioned earlier, investor category cases. If you've got $1 million, come see me. Religious workers, U visas, and T visas. We're going to talk about priority dates and what they mean. We're going to talk about visa expiry versus your I-94 expiry. And we're going to talk about remaining in status. We're going to talk a lot about status because I want to make sure that none of you get stuck by falling out of status. It's very important that you stay in status. That is critical for all of us as international students. But why do I say all of us? Because once upon a time, like you were, I was an F1. So I know very well how important it is to stay in status at all times and not run afoul of the immigration authorities. So what are some of the non-immigrant work authorized categories? F1, J1, M1. M1 is for vocational students. During that, you could get your CPT, which is curricular practical training, or OPT, which is optional practical training. That is post-completion after your degree. You've got the H-1B, which is a work visa. You have the H-2A, which is the agricultural temporary non-immigrant visa. You've got H-2B, which is non-agricultural temporary visa, only $66,000 per fiscal year. And the H-3, which is a trainee visa. We also have the O-1 or alien of outstanding ability, the L-1A or B, which is the intercompany transferee or intercompany intercompany worker with exceptional ability. They're there for a specific skill. The E, treaty trader or treaty investor. And then of course you've got dependents who also must stay in status. Those would be the spouses and the children of the principal F1 or H1, etc. Okay. What are some of the processes we go through in employment-based visas? The processes we go through are entry as a non-immigrant, that would be F, J, or H, OPT or other work authorized status after that, the employer petitions for I-140 approval, or it could be self-petition, filing for adjustment of status, which is the green card. Hopefully your priority date is current and you can file for adjustment of status, or consular processing. And therefore you need to remember, once again, as we talked earlier, stay in status at all times. Finally, the approval of the green card or legal permanent resident status. Hiring a foreign national. What does your employer have to do? They're going to ask you, what's OPT? You've graduated, what's OPT? For many employers, especially smaller employers, the first time they encounter immigration is probably when you walk in the door for the interview for the job. And they're not going to know anything about immigration. To them, it's a very scary topic, like paying taxes. Nobody knows about immigration. Nobody wants to deal with immigration. Nobody wants to waste money and time on government bureaucracy. So sometimes you've got to convince them and explain to them what they have to do for you and make it simple for them so they understand it is not so hard if you get a good qualified attorney to represent the company. So what is OPT? You all know what OPT is, optional practical training. You've graduated, you get 12 months of OPT, or if you have a STEM degree, science, technology, engineering, or mathematics, you get another 24 months on top of that for a total of 3 years. Timing of your OPT is crucial. Then during your OPT period, hopefully you change your status to H-1B. What's an H-1B? An H-1B is a work authorized visa good for 6 years with a particular employer. You can change employers during the time of your H-1B. You can also, in some cases, you can also, if you need to, go from one employer who is cap exempt to another employer who may be cap subject. But all of those are highly technical issues. However, one very important thing, there's only a total number of H-1Bs each year of 85,000. That's it. 65,000 are given to individuals who have a any degree, bachelor's, master's, PhD. Another 20,000 are reserved for individuals who have a master's or higher degree from a US university. So there's two sort of slots in the H-1B. Recently, the H-1B process was changed. So instead of employers filing all together on April 1 of each year, there is a lottery system. The lottery system opens up, let's say March 1 of each year. If you're selected in the lottery, then you file your full application beginning April 1 of that year. They started out doing this process this year, and there were over 200,000 H-1B applications. Only 85,000 were selected, and only those could file their H-1B applications on or after April 1 of this year. Same thing will happen next year. What's an O1 status? As I said earlier, alien of outstanding ability. If H-1Bs aren't available, maybe you can go to an O1, provided you are outstanding. What's an L1? L1 is intercompany transferee. Maybe there's no H1 available. Maybe you're not that outstanding. Perhaps if you have a potential employment with a foreign company in the past, you've had that employment, you have potential employment in the USA with a branch of that company or an affiliate of that company, you could get yourself an L1 as well. So those are some of the non-immigrant visa categories. H-1B visa, what is it? As I said earlier, it's for professional employment of up to 6 years, minimum requirement of a bachelor's degree, and payment of the prevailing wage. A very interesting development happened just last week. In the last 2 weeks, excuse me, the Department of Labor came out and said, we're now going to change the prevailing wages, and they increased the prevailing wages enormously for H-1Bs. And there's an article actually on my blog, www.immigration-america.com, which talks about what the Department of Labor has done with those prevailing wages. And all of this is in keeping with the Trump administration's desire to essentially get rid of H-1Bs, to discourage immigration to the USA, both legal immigration from the family side, as well as legal immigration from the employment side. There's something called premium processing. Premium processing is when you pay the USCIS an additional fee in order for the USCIS to process your application much faster. That fee is going to be increasing enormously very soon. So are the filing fees for most other applications. They are going to be increasing as well. Can your H-1B be extended? Absolutely, it can. The H-1B is granted only for 1 year at a time. The extension can be for another, forgive me, the H-1B is granted for 3 years at a time, only 1 year at a time if you are going to be an employee that's moving from location to serve different clients. That 1 year can be extended, that 3 years can be extended, but extra applications have to be filed with the USCIS. So yes, an H-1B can be extended up to a maximum period of 6 years. Can your H-1B be transferred from one employer to another employer? Yes, you can petition the USCIS once you have an H-1B to transfer that H-1 from employer A to employer B. Okay. What's a cap and non-cap H-1B? Remember I told you about the 60,000, 65,000 plus 20,000 visas for H-1Bs. Well, if you go to work for a non-profit hospital, which also has a teaching hospital with it, or you go to work for colleges or universities, or you go to work for a governmental research organization, there is no limit on the H-1B cap for those particular employers. So if you go to work for one of those particular employers, you're not counted against that H-1B cap. So you don't have to worry about the lottery. You don't have to worry about being selected in the lottery. You don't have to worry about not having a chance to participate in the lottery. You go directly to apply for your H-1B, which is a wonderful thing, provided you're hired by one of those employers. Okay, recent issues of concern. There's a policy of deferring to prior employers and prior approvals in the same case, same petitioner. They're not going to do that anymore. There was a executive order called Buy American, Hire American. That's why I have BAHA. Buy American, Hire American executive order specifically targets H-1Bs and all immigration in general. There's new requirements for USCIS interviews for all employment-based cases. There's also, as I said earlier, the new pre-filing selection under a lottery for cap subject H-1Bs. What did the executive order say? The executive order said the following: the US Department of Homeland Security shall, in order to protect the interests of US workers. And because of COVID right now, the US government is saying, we don't have enough jobs for US workers. Let's get rid of the foreign workers. Let's get rid of the H-1Bs. So that becomes very difficult for individuals like you are, and even more difficult sometimes for individuals who are your employers, who are depending on you to do work for them that you have the skills to do, because they can't find a US worker and they are desperate to have a US worker. Okay. So the executive order, as I said, has put a serious crimp into employment-based immigrant and non-immigrant purposes. Section 5B of the executive order says, ensure that H-1B visas are awarded to the most skilled or the highest paid petition beneficiaries, which is also very sad because there's many small companies that are genuine companies that could really use and benefit from a foreign worker who may not be able to hire a foreign worker because the wages have gone up so much. Remember, I told you at the beginning of this month, a couple of weeks ago, the US Department of Labor changed its rules to require that the prevailing wages that are paid to US workers are much, much higher. And that's a real shame because it's going to deprive US businesses of qualified, skilled people like yourselves. That's the sad part about it. So next year, those of you who are graduating, unless this administration changes and these rules don't go into effect, you're going to be fighting very hard to get an employer to hire you, and then fighting very hard to get an H-1B visa to continue to live and work in the USA. Okay, so these were the changes that came in October 2020. As I said, there are articles on my website, immigration-america.com, for detailed analysis. Please visit my website. The wage structure and the additional structural changes to H-1Bs, which came out from the Department of Homeland Security. Now, with regard to the first one, the new wage structure, that one already has been stopped by litigation through the American Immigration Lawyers Association, of which I am a member. So that one is not going to go into effect at this point in time. There's litigation going on. If a nationwide injunction is passed, unless that injunction is lifted, it's not going to go forward. So please be aware of that and stay tuned. Visit my website for any updates on that issue. The electronic processing rule, I do apologize. I think that some of this may be hard to see, but Maxwell does have the presentation. So Maxwell, you could always make it a PDF and send it to whoever needs it. Or if anyone needs it, email me. I'll be happy to make it a PDF and send it to you. The H-1B electronic processing rule will require, as I said, the pre-application process coming up in March of next year. Only 85,000 visas, only 85,000 applications will be selected, and only those will be able to file for the H-1B. What's needed for that pre-registration? Some very general and simple things. Takes about 10 minutes to do the pre-registration. It is not difficult at all. Once it's done and filed, you will be able to see what the USCIS has assigned as a case number, and you can check on that case number online. Between the time that you have the H-1B, you have to also get something called a labor certification application. What's an LCA? An LCA is when the Department of Labor agrees that the wage that is being paid to the employee meets the minimum standards for wages and doesn't take away money from US workers. The Department of Labor has moved to the FLAG system, Foreign Labor Application Gateway online system, and an LCA application has to be filed through this FLAG gateway system. If you change your job or you get a promotion in your job, you have to file a new LCA and you may need to file a new H-1B. Keep that in mind. Okay, we've talked about non-immigrant visas. We've talked mostly about the H-1B because that's the workhorse non-immigrant visa. If you have questions on other visas, please visit my website, again, www.immigration-america.com, or as you can see on the bottom of your screen, www.usimmigration.biz. Okay, so we talked about non-immigrant visas. So now let's talk about immigrant visas. And your question might be, what's an immigrant visa? An immigrant visa is a visa, or rather colloquially, a green card. That's what allows you to live and work permanently in the USA. That's a green card. So we're going to talk a little bit about immigrant visas. How many different categories are there of applications we can make for a green card through employment? We can file as an EB1, outstanding professor or researcher, EB2, advanced degree or national interest waiver or perm application, EB3, professional or skilled worker or perm application, EB5, which is the investor visa, and EB2, Schedule A, Group 2, exceptional ability, aliens of exceptional ability. And of course, as I say to all my clients, beware the backlogs, because there's lots and lots of people waiting in line for these visas. And when there's lots and lots of people waiting in line, you know, and I know, those lines are going to get very long. And there's a limit on number of visas that can be issued every year. So students and friends, please be aware that there are backlogs in the visa application process. So you've got to be very patient. And again, as I said earlier, the key is you've got to maintain status in the United States while you're waiting to apply for your green card. Okay, what's the how do I advise my clients as to whether to select one or another of these different application types? I look at your qualifications, the job requirements for the job you'll be doing, the salary that you're offered, the DOL requirements, Department of Labor requirements, the processing times at the USCIS, and then the backlogs in the priority dates. Those are the criteria I use in order to determine whether you should file under one of those categories on this slide. Here's a simple flow chart of how the process works. You obtain your work authorized non-immigrant status. That may be your H-1B, your O-1, your L-1A, L-1B, whatever it might be. You decide, am I going to do a perm processing, which is a labor certification, or directly file an I-140? An I-140 is an immigrant visa petition directly filed by the alien if he or she is either, as you may remember, an alien of extraordinary ability or an alien of exceptional ability, because they can file for themselves. You file the application gets approved, then you file the application for adjustment of status if your priority date is current. And what's this, where it says concurrent filing with the little asterisk? What's that asterisk for? That says you could file, if your priority date is current, you could file concurrently, meaning together, both your I-140 petition as well as your petition for adjustment of status or for the green card. So that's what concurrent filing is. Priority dates, what are they? Who sets them? Why do we need them? How does it affect your immigrant visa? How do you plan around visa backlogs? What's the Child Status Protection Act? What are H-1B extensions due to the priority date backlog? So let's check on that. Okay, here we go. This is some scary stuff. And I'll tell you what, I'll flip to the next slide because we're doing immigration based on employment. Employment-based priority dates. Most countries in the world are blessed. They've got this CCC, as you can see, okay? That means current. Now, what is this chart? This chart tells you that if you have applied for an immigrant visa under any of these categories here, whether you are eligible to apply to get your green card depending on the country where you are born. That's the top row over here. The whole world is here except for China, El Salvador, Guatemala, and Honduras, India, Mexico, Philippines, and Vietnam. And really, these are here more because of the fact of their religious worker visas, and for Vietnam investors, whereas Guatemala, El Salvador, etc. are here because of something called unaccompanied minors and U visa holders. So that's why they are here. U over here isn't U visa, it means unavailable, just unavailable. There's so many visa applications in line, those visas are used up. They don't have any visas to give out for this particular month. Now, what does this chart mean? And I don't want to take much more time on it because it's highly technical. This chart means basically these are the dates that people are waiting for, that people have been waiting for since in order to apply for their green cards. So for example, if you are a first preference alien and you were born in India, if your application was filed on or before June 1st of 2018, then now in 2020 October, you can apply for your green card. If it's even worse though, if you are second preference, meaning master's degree, born in India, you are waiting and waiting and waiting because you can't file a green card unless your application was filed on or before January 1 of 2009. That's 11 years. So it's very, very scary, especially for people born in China, born in India. If you're born anywhere else, you're fine. Why? Because under the immigration law, no single country could use more than 7% of the visas in any particular visa category. India and China send the most skilled aliens to the USA for higher education. So when all of those aliens apply for visas and stand in line, the line for India, the line for China is much longer than the line for any other country. So all the other countries are current. India and China are oversubscribed for first, second, third, and other worker categories. And China is oversubscribed even for investor visas. That's if you have $1 million or more, or $500,000 or more, and you can create up to 10 full-time US jobs. If you can do that, then you are eligible to apply for a regional center or non-regional center investor visa. Okay. EB immigrant visas. The first part is PERM. PERM is a standard labor certification application. What does it mean? The employer applies to the US Department of Labor. That's what DOL means, and says to the Department of Labor, look, I've advertised the job, I've searched the US market, I've given US applicants a chance to apply, but I cannot find anyone who's a US citizen who's ready, willing, able, and qualified to do the job. And so I have to hire the alien. Please issue a labor certification for me so I can file that labor certification together with a green card application if the priority date is current with the USCIS and get my employee a green card. That's basically what the PERM process means. Now, students, don't be overly concerned and confused. Details on all of these things are on my website, www.usimmigration.biz. Go to the website, search for the topic you're looking for, whether it's labor certification, i.e. PERM, or EB1 visas, EB2 visas, H1Bs. Please search on the website. You will be able to find articles that come up on the website. There's probably over 150 articles on my website on all topics ranging from asylum to family immigration to employment immigration to citizenship. So please go to my website and check it out, www.usimmigration.biz. Okay, once the PERM application is approved, as I said, file the I-140, file concurrently for the green card as well. Okay, who can self-petition? An alien of extraordinary ability can self-petition. Who are these aliens? They have ability that is extraordinary. That means you've got to be someone who's at the very top of your profession, ladies and gentlemen. You've got to have publications, recognitions, awards, peer review of books or journals in your field, highly respected, perhaps a professor, perhaps having a tenure track position at a university, things of that sort. Then you're an alien of extraordinary ability. It's one of a very small percentage of people who've risen to the very top of their field or their profession. That's how the USCIS describes it. Okay, you are going to continue that work in the USA. The entry to the USA will benefit the USA, and you file that application on Form I-140. The other two categories of EB1 are outstanding professor or researcher. To be outstanding, how do you qualify? How do you prove that? You receive at least 2 of the major prizes, international or national awards, memberships in professional associations, publications by the immigrant, written about by others in professional publications. You're a judge of the work of others. Your original contributions to the field. You must have tenure track or research positions at university or facilities, okay? So all of those are required in order to be qualified as an outstanding professor or researcher. You could also qualify as a multinational executive or manager, as an L1A. For that, you must show job creation, taxes, benefits to the USA. You must show your managerial or executive nature of your position, which is defined in the Immigration and Nationality Act, and it's highly scrutinized. You avoid the PROM process. That's the advantage. There's no prevailing wage requirement, but it's not suitable for smaller companies. I would avoid it if it's a small company, a 2-person, 3-person, 10-person company, because USCIS is likely to reject it, saying this person isn't really required to be a L1A. We give you the L1A for non-immigrant purposes, but not for immigrant visa purposes. So it's a very complicated, sometimes it's pretty arbitrary process, if you really ask me, some of these decisions. And we have actually appealed some of these negative decisions to the Administrative Appeals Office of the USCIS, and we have won because their position has been so outrageous. Okay, national interest waiver. Again, the alien can apply on their own, as I said at the bottom, can self-petition for a national interest waiver because it will show, they are creating, or they've got a process, or they have something that's going to be beneficial to the USA, hence the words national interest. The standards for national interest waiver have been relaxed somewhat after matter of Dhanasar came out. That was a court case that came out through the Administrative Appeals Office, and they overruled the very negative decision of NYSDOT, New York State Department of Transportation. Given the current political and economic climate in the USA, it may be interesting to see if they try to bring back NYSDOT in some way or the other, perhaps through regulation. EB immigrant visas, path 4, the 4th way to do it, Schedule A, groups 1 and 2. There are shortages of certain types of aliens in this country, specifically professional nurses and licensed physical therapists, including other professionals such as, Schedule A, Group 2, aliens of extraordinary ability, not EB2, this is a different schedule. And also, here's how you qualify. You must be an alien of exceptional ability, not an EB1 or EB2 person, and you could qualify under Schedule A, Group 2 of the Immigration and Nationality Act. Again, you need a prevailing wage and an employment offer. This cannot be self-petition. This has to be done by the alien's employer, not by the alien. The investor visa, we talked about that. If you have $1 million of $500,000, create at least 10 full-time US citizen jobs. You get conditional status for 2 years, and then unconditional status. You can apply to remove those conditions, and then you get unconditional or full LPR status. There is a non-immigrant option for investors as well. If they don't want a green card, for example, they can apply for the e-visa, provided their country has a treaty of commerce and navigation and friendship with the United States. So if they have a treaty with the USA, they can apply for the non-immigrant option of the e-visa. Okay, some key statistics about immigrant investors. They are more than twice as likely to start a business each month. And again, in 2010, immigrants are 3 times more likely to file patents than US-born citizens. That's true. If you look at the Patent and Trademark Office, look at some of the great trademarks and great patents that are out there. They're all filed by people who entered the US as immigrants. It's amazing how many immigrant inventors there are in the Hall of Fame at the US Patent and Trademark Office. Okay, and by the way, the US Patent and Trademark Museum is right here in Akron, Ohio, on High Street and Broadway in downtown Akron. So please, if you have a chance, come visit it sometime. What does the executive order that we just saw, the Baha executive order, mean for the graduating student or the EB1 or EB2 self-petitioner? It means the standard of review will be much higher. The entry-level worker wage will not qualify because they've bumped it up so high, and it will be very difficult to qualify other than for very highly skilled and very highly paid H-1B workers. We're already seeing this with the H-1B pre-certification and the new flag system. So what am I advising my clients? I'm saying you must have substantial proof of your abilities, and the quality of your work or research must be at a sustained high level. If you're applying for an H-1B, you must have a much higher than an L1, level 1 entry-level wage. And we know now, just last week, as I said, Department of Labor has increased the wages by a huge percentage. For example, the entry-level wage was at the 17th percentile of all wages for that occupation. Only 17th percentile. Now the entry-level wage for a particular occupation has gone up to 45% of all wages for that occupation. So almost 50%. And they're saying someone must make at least 45% to be considered entry level. So those 4 wage classes they have, level 1, 2, 3, and 4, have been smashed together into only 65% of all the available wages, which is really very, very difficult for any employer to be able to do. Forgive me, 55%, which is very difficult for any employer to be able to afford, unless they are super rich, a cash rich Fortune 500 company. The job description must be higher than that for an entry level position, and there will be a adjustment of status interview and form 245J for Juliet, which is the adjustment of status additional form based on the requirements of Baha. So that summarizes my presentation in a nutshell. I'm very happy that we got through with more than enough time to spare. Just keep in mind, ladies and gentlemen, this is only a general presentation. It's not legal advice on your specific case. Please do consult a qualified attorney. My address is at the bottom. I'm in Cuyahoga Falls, not too far from Kent. I'm happy to serve you. You've got my phone number there. You've got my website there. You can contact us by email or by phone, and we try to get back to everybody within 24 hours. So that wraps up my presentation. Max, I see you're back online. Thank you. And hopefully nobody fell asleep. All right. Now I'm ready, my friend, for questions. If anyone has questions, please type them up, send them to Max. He's going to review the questions, and he and Ainur will get those questions over to me. So I'll give you a few minutes to compile your questions, Ainur and Max, and then I'll be ready to answer them at your discretion. Back to you.
And thank you very much for this presentation. I must say,
pleasure.
It's very informative. It covers a lot of ground. You talk about almost everything related to immigration, and that's very important because we all have different issues pertaining to our immigration status. And I'm very happy that you addressed something that would touch on everybody's issue. And it was not quite specific. It was very broad and very encompassing. So thanks for that presentation. So I'll just go ahead and ask Ainura to read some of the questions that she has to us. I think some people have already asked questions in the chat box, but as I said, at this point, if you also have a question, you can just turn on your video, you can raise your hands, and we will call you so that you can unmute your microphone and ask your question directly to Mr. Setna. But we will do that together with the questions that Ainura will be reading to all of us. So Ainura, just go ahead now.
Yes, hello. Again, thank you so much, Mr. Setna, for such informative lecture. And it was really interesting to listen. And I'm sure, I don't think anybody fall asleep because it was really interesting. So I have a few questions here.
I don't know, Max
Yeah,
is rubbing his eyes. I don't know, I just saw Max rubbing his eyes. Go ahead, please. Sorry.
I don't know. No, I was listening. I mean, for me, it was really interesting.
Thank you for having me. I
Okay,
appreciate it.
so
Go ahead.
uh,
What's your questions?
thank you. Yeah, so I have a few questions about, for example, like a Trump administration. So Emma is asking, Trump administration banned marriage green card for international students if they marry a permanent resident while they are still in school. Do you know about this
No,
ban?
that's completely untrue. I'm going to tell you something. Students, listen to this very carefully. Okay. I'm going to say this very directly. Trump would like to think that he is God. He is not God. We have a system in the USA, which is a democratic system in which the laws are passed by Congress. The law regarding benefits to aliens is passed by Congress. It is codified in the Immigration and Nationality Act. Trump cannot change the law by an executive order unless there is some kind of a national emergency, and that's only for a specific time, for a specific purpose. So there is no change to the benefits that a permanent resident can grant to a spouse who is not a permanent resident for immigration. So in other words, if a non-immigrant marries a permanent resident, the permanent resident can still apply for a green card for his or her spouse. I just want you to be very clear about that. Don't believe everything you see or hear on the internet, okay? Everything you see or hear on the internet is not necessarily true. Look at the facts, look at who's reporting that fact, make sure you have the right data before you believe something, especially from the internet. But that's a great question. And I'm glad that was the first question, because I think it gives all of you listeners the knowledge that don't believe everything you hear, especially about immigration. Trump doesn't have the power like a dictator to wave a wand and wipe out the law. He can't do that. Ainura, your next question.
Thank you. So next question. It's also about new rules under the Trump administration. So about the proposal of new DHS status and F1 duration. So do we know how it would affect students who are already in US under an F1 visa? So would it work like retroactively?
Generally speaking,
I before you go ahead, I had a question related to that. So when you were presenting, you mentioned the fact that DHS is proposing to make changes in the status for F1 students, where it will not be duration of stay, it would be specific term limits, so 4 years, 2 years, whatever. So the question is asking how that proposal is going to affect students who are already in the US with F1 visa. Would they also be limited in their number of years they have to stay in the US? Do they have to go back to their country? How is going to change for them? And I also had a question related to that. Would that proposal automatically become a law? Does it have to go through a process? Is there a way it could end up not becoming a law? So that was my question.
That's a great question. And I'll give you the answer the way I would present it to my students in my immigration law class. Whenever you are looking at an agency, in this case, the Department of Labor or the Department of Homeland Security, is proposing something, they are not proposing a law. They're proposing a regulation. Only Congress can make a law. the agencies can only create regulations. Regulations do not have the force of law. In fact, regulations are often challenged in court. One of the main challenges that is brought forth against a regulation is that it did not follow the Administrative Procedures Act. Now, I know that's getting very technical, but to give you an idea of what that means, it simply means that when the agency created the regulation, they didn't follow the proper procedure for writing the regulation, publishing the regulation, and providing a notice and comment period for the public to comment on the regulation, and then making the regulation final based on the analysis of those notices and those comments that they received from the proposed regulation. So there's many cases pending which have resulted actually in injunctions against this administration, meaning they can't implement those regulations. They cannot, because there's no law. It's different for a law. If a law passes, then the burden is higher, because under the law, Congress has the right to regulate immigration. But agencies don't have the right to regulate immigration if they do not follow the procedures under the Administrative Procedures Act. So consequently, any proposal right now is just a proposal. It could be reviewed and changed. It could be challenged in court once a final regulation comes out. Or if the administration changes, as it might next Tuesday, effective January 20th, 2021, there may not be any change at all. So don't get panicky right now. Don't panic, don't worry. Just be aware of what's going on and stay tuned, for example, to websites like mine for good, solid, fact-based information, not fake news, not something that some politician says on television, not something that you heard saw on the internet, but real news from real people who know what they're talking about.
So I think Clarissa asked that question and she's raised her hand. So I think she has a follow-up before we move to the next question. Clarissa, you can go ahead and ask your follow-up question.
Yes, hi. My concern is more related to how fast this administration has moved in pushing forward their proposals and getting their way, kind of.
Yeah.
So even though the proposal is still a proposal, I wonder if, since the public comment period ended on the 26th for this proposal, I wonder if the next 3 months before the new administration, if it's a new administration actually takes the lead in the country, if they can actually do anything in the period of those 90 days. And if there's anything as that we can do to prepare for that as F1 students who are already here. I know that as graduate students, a lot of us are PhD, so it's very unlikely for any of us to complete our program in the 4-year period of an F1 as proposed in a new proposal. So I was wondering if there's anything that they actually can do in the next 90 days before the new administration takes a seat, or if there's anything that we can do to prepare in case the proposal becomes law and how it would affect us.
That's a great question, Clarissa. Where are you from, by the way?
I'm from Italy.
Italy. I figured that. I could tell. Okay, wonderful. Well, Clarissa, great question. Again, students, do not be afraid. Here's why. You already have a visa in your passport. You already have an I-20. You already are working on your program. You entered the USA with certain expectations. You didn't expect those expectations to change halfway through. If the regulation is finally put into effect, meaning it's published in the federal it's published in the federal publication, which is basically the mouthpiece of the federal government. It becomes part of the code of federal regulations. Once it's published in the Federal Register, there will be litigation, Clarissa, which means there will be lawsuits brought by first of all, by universities. all the leading universities are going to push back on this, just like they pushed back against SEVP in the beginning of this fall semester. Remember, SEVP had said, oh, we're going to require that all students who are here in the USA take at least one class in person. Otherwise, they have to go back home. Do you remember that?
Yeah, that was scary.
And that was scary. That was super scary. But what happened? Big schools like Harvard, MIT, they jumped up. The next day, they sued the damn government. They said, this is ridiculous. How can you force students to go to a campus when we've got COVID raging around the nation? And what did SEVP do? What did ICE do? They said, whoops, too much pressure. And they stepped back. Why did they step back? Because they knew that if these schools had to go to a full-fledged hearing in court, they would have won. So they gave up. And that's exactly what's going to happen. If they come up with some stupid regulation, which has no real basis for any sort in order to exist, other than simply anti-immigrant sentiment, universities are going to jump up and they're going to oppose those regulations in court. You're going to get another nationwide injunction. And by that time, God willing, there's a new administration and that regulation will quietly be dropped from the books, because the new administration has a right to rescind any regulation imposed by a prior administration within the last 6 months of its existence. Does that answer your question, Clarissa?
Yes, I appreciate it.
So don't worry, okay? There's mechanisms in place to address these last minute, last gasp efforts by the Trump administration to derail immigration, even for lawful students, which makes no sense at all. If you're trying to make America great again, wouldn't you want to have smart, brilliant, highly educated people like you staying in this country? It makes no sense at all. I mean, if the man claims to be such a great businessman, he's done all these businesses and all these great things. He's married a woman from another country, for God's sake. Does he realize that immigrants bring life to the United States? That's what I don't get. It's pure populism, plain and simple, and it's going to hurt America. I think enough of people have become fed up with it. We're going to see a huge backlash if he tries to do this and implement these kind of rules against people like you.
Thank you. You really answered my question and kind of cheered up my spirit a little bit.
Absolutely. This is a pep talk. It's a rally.
Thank you.
Ainur.
Okay, thank you. I just have also quick comment. So also you said about like restructuring and increasing the wage for work visas, and you said it was also protested, right?
That's correct. There has already been a lawsuit filed against that policy by the American Immigration Lawyers Association, and I believe 20 large employers, including, I want to say, at least a couple national associations. Yes, that's correct, I know.
Okay, good. Thank you. So now we have some more like kind of personal particular questions. So question from Manpreet. I don't know, maybe it will be a little bit hard to understand. Let me know. So he's saying that he's a graduate student on L2 visa, and his visa is expiring on April 16th in 2021. And he will be taking 2 last courses in spring 2021, which will run through May 15, 2021. So he has following questions, 2 questions. So first, he wants to understand how will it work if he wants to change to F1 visa from January. And second question, if he changed to student visa, will he be eligible for OPT, considering that he will be on F1 only for 5 months?
That's a great question. And I'm going to be very honest with you. First of all, changing a category of visa is not a problem. It's allowed in the law. But here's the reality. Ainur and Manpreet, here's the reality. the reality is not going to make you happy. If you have not already filed your application to change to F1, forget it. You're not going to get a change approved for 6 months, 8 months, 1 year. That's how long it's taking USCIS to approve simple applications for change of status or extension of status. I have clients for whom I've applied for extension of status for tourist visas for 6 months ago previously, and I'm still waiting for the USCIS decision. That's how bad the USCIS processing has become, especially under this administration. So if you haven't yet applied for your change of status to F1, forget it. You're going to be out of luck. Number two, with regard to your question about how long you can stay, most visas have a grace period, okay? Unfortunately, you said, I think I heard Ainur say that you are an L2. Is that correct, Ainur?
Hi, this is Manpreet. So yes, I'm on L2. My husband is on L1A. So I'm
Excellent.
as his dependent.
Excellent. So can your husband extend his L1A?
Yeah, he's working with his company. He works
Well,
for.
then if his L1A gets extended, they should have filed, Manpreet, the extension of your L2. Did he not file
No,
simultaneously?
it is not yet filed. They're working on it. So
Okay, when they file it, Manpreet, make sure that your I-539 is part of the packet so that it goes to USCIS together with your husband's L1A petition, so that when they approve the L1A, they concurrently also approve your L2 extension of stay. Do you understand?
yes, I do. But
Then
then
you're doing
I
good.
actually wanted to know about I am not allowed to work on L2. So I have to apply for EAD. So that is why I was thinking if I shift to F1, and since I'm on a STEM degree, I can get a 3 years OPT. So
Actually,
I don't
that's
need my.
not true at all. An L2 spouse of an L1, if he's an L1A,
Yes.
work. Who told you you can't work?
No, I have to take an EAD, which takes
Correct.
almost 6 months.
That's a lot easier to get an EAD as an L2 than it does to go on F1 status, pay your full tuition, wait for a year to become changed over to F1, and then apply for an EAD after your OPT. Right now,
Okay.
you've been working all this time on an L2. You could have been working from literally 3 months after you came to this country as an L2.
Yeah.
Okay, so
Yeah.
that's what I would have done. I've got clients who are L1s whose spouses, as soon as they get here, we apply for an employment authorization document. Takes about
Yes.
30 days. They get their EAD. They can go get their driver's license, get their social security card, and they can start working.
Yeah, I took everything, but I started studying, so I didn't start working as
Understand?
of now.
Okay, so let's move on to the next question then, Ainur.
Thank you so much.
You're welcome, ma'am. I can't hear you, Ainur, because your mic is muted.
Ainur, you're muted.
Yep.
Okay, sorry. Okay,
That's
sorry.
okay.
Okay, my next question is, does it really matter, like in what state do you apply for
Not at
work
all.
visa or green card?
Not at all.
Okay.
Immigration, Ainur, is federal. The quotas are national, meaning for the whole country. The applications are sent to service centers, which are remote outside the states. They have nothing to do with state law whatsoever. So the answer is no. There is no quota. There is no restriction because immigration law is federal. In fact, I, as an attorney, I'm licensed only in Ohio. I could travel anywhere in the USA, and I have traveled to other states as well to represent clients because my license in Ohio allows me to practice federal immigration law, which is uniform throughout the entire United States.
Okay, good. Thank you. Hello?
Yeah, I'm here. Your next question.
Okay, next question from Sandra. So she's asking, under what conditions can she change from an F1 to J1 visa?
Well, you know, Sandra, that's a great question, and I really can't give you that answer because I don't know enough about your case, nor would I be able to give you a good answer. Even if I knew a little more, it would still be guessing. There's too many parameters. You're better off in that case setting up an appointment with a qualified immigration lawyer. And I'm not pushing myself on you at all, okay? But you're better off getting an immigration lawyer to give you assistance, or perhaps initially at least going to your international student office at Kent State University and asking them that question.
Okay, thank you, Fahad. So next question I have from Jess. How difficult is to move from an OPT to H1 visa?
I'm sorry, say again, what's the question, please?
How difficult is to move from an OPT to H1 visa?
Well, I'll tell you what, Ainur, the question, excellent question. We covered it a little bit in the presentation. In a nutshell, the process is at least 3 steps, and let me explain. The first step is going to be to file a pre-filing application with the USCIS. The filing fee for that application right now is a nominal $10. It has to be filed by the beginning of March. There's going to be a window available. By the end of March, the USCIS will collect all those pre-filing applications. We covered that in my presentation a little while ago, and will put them into a lottery system and will spin out 85,000 lucky winners. Okay. When you get, if you're a lucky winner, then your company, the employer, can file for the H-1B beginning April 1 for a 90-day period. So that's all of April, all of May, all of June. If you don't file by June 30th, you won't be able to get your H-1B. Second part of this issue, as I said, you've got to file a labor condition application with the US Department of Labor. Now, if the new regulation by the Department of Labor stands, meaning it's held to be valid by a court of law, your employer is going to be paying a much, much, much higher wage than the employer thought they would be paying initially, which means that H-1B may not be, that employer may not be willing to proceed with that H-1B anymore because they're going to be paying twice perhaps of what they thought they would be paying. Third, the H-1B application itself has to be filed, as I said, within that window. The standard for H-1B applications has increased enormously thanks to the Buy American, Hire American Act. Now, that, not act, forgive me, that was a wrong word, forgive me, executive order, okay? That law, that executive order, excuse me, I keep on saying law and that's wrong, forgive me, I'm completely wrong. That executive order, that's all it is. Trump would like to think it's the law, but it's not the law, it's an executive order. That executive order has made it very hard for H-1Bs to receive certification, validation, because USCIS is afraid that by approving H-1Bs, they're going to make their boss, Trump, mad. So we see more and more requests for evidence. We see delays in the process. And consequently, people who are on student visas have their OPT risk sometimes running out of time because their H-1B is not approved in time and they can't remain indefinitely in the USA, or they will accrue unlawful presence. So in answer to your question, Ainur, and in answer to the person who asked the question, it has become increasingly hard to navigate the H-1B process. I would not advise an employer to do it themselves. They should go to a qualified attorney.
Okay, thank you.
It seems two people asked a similar question. So if any of you have a follow-up to your question, you can go ahead now. If not, then I know I will skip to the next question.
Ainur, do you have a follow-up to the question? Or is there anything else you want to ask on the same?
Yeah, I just have a question. So basically, yeah, can you hear me? Yeah, I have just a
I
follow-up
can hear
quick
you
question.
just fine.
So basically, if you change your status, so is it considered that you are able to stay in US if you change of status visa is going to
It would
end?
depend. I know it would depend. I'll assume for purpose of this question, because it's not a very clear question, and that's not your fault. You didn't write the question. I'll assume that the person who's asking the question is saying, if you change your status, let's say to B1, a business visitor, or B2, visitor for pleasure, can you stay in the US? Absolutely, you can stay, as long as your status is granted within the time of your legal F1 status or your F1 status plus your STEM OPT extension, or your F1 status plus your grace period. If you fall out of status, remember, you may be barred from re-entering the USA. Do you want to take that chance for the rest of your life, not being able to re-enter the USA versus staying here for just a temporary period? That's a chance you've got to take.
Okay, now I see. Thank you.
You're welcome, Ainur.
Okay, so next question. What is the transition from H1B green card or to job?
Okay, what is the transition, Ainur, from H1B to, I couldn't get the last bit of your
To
question.
green card.
Oh, well, the transition is in my presentation. Essentially, you have an H1B. That's a non-immigrant visa. While you have that non-immigrant visa, you want to convert that to an immigrant visa. So you apply through your employer for something called the PERM process, or EB1, EB2, based on your qualifications. As I said, there's a slide. I analyze each and every client's qualifications when they come in to my office to evaluate what's the best type of visa that they would be eligible to, or not best of visa, best category, best preference they would qualify for in order to get them their immigrant visa the fastest way. So once that petition is filed, that's usually filed on form I-140, I-140, immigrant petition for alien worker. Once that is approved, that alien can, if the priority date is current, can apply for a green card. So that's the process in a nutshell. It's a very involved process. It takes a long time. But yes, it's something that we do every day here in this office. It just requires patience, and it requires the fact that the priority date has to be current before we can apply for the green card. Most countries in the world, as you saw from the priority date chart, most countries in the world have current priority dates for EB1, EB2, EB3. Only India and China are backlogged.
Hi, I asked the question. I'm Sarah, and I wanted to ask another. It's the same question. So, under what condition the employer would be willing to file the green card after the H-1B? Because is there any obligations to work with the same employer under the green card if they file it for you, or is there any other circumstances that they would will to apply for the green card instead of extending H-1B until 6 years?
Well, you know, Sarah, that's something I cannot predict for you because it's your employer. And I will tell you this, students, I will tell you this upfront. I know that you're all scared of not finding a job. I know that you're all worried about the future. I know the COVID pandemic has us all concerned and worried. And those are all very valid fears. I'm not going to take that away from you. I know, I was there. I was a foreign student once, remember? So consequently, what I'm going to tell you is this. When you go to talk to an employer, tell them at the beginning itself, look, I'm a foreign student. I have OPT. I can work for 1 year or 1 year plus 2, which is 3 years if you have a STEM degree. But you have to apply for an H-1B for me. And after we get the H-1B, I'm going to need help to get a green card. I'm going to need your advice, your assistance, and your support to get the green card. In return, I will work for you. I will not move my job. I will not move my location. I will be here and I will work faithfully for you, so that the amount of money you spend training me, investing in me, supporting me, will be something that you will recover through my long-term employment. That's what I can offer you. You, Mr. Employer or Miss Employer, are you willing to do those things for me for immigration? If they are not willing to do those things for you, Sarah, say thank you, have a good day, go to the next job interview. That's what I would do. I would be very upfront with them, because the last thing you want is to have an employer who says, oh, I didn't know this and I didn't know that and I can't help you. And you're sitting there and it's 2 years into your OPT or 2.5 years into your OPT and you don't have even an H-1B visa at that point in time.
Great, thank you very much.
You're very welcome.
Yes, but I think it's really hard to find an employer who would agree for these conditions.
Not
Yeah.
really, not really.
Yeah.
If you are that good, how do you think I have a practice, Ainura? How do you think I file H-1Bs every year? How do you think I file green card applications every year? How do you think I file I-140 petitions every year? Because I have employers who realize the value of their alien employees and who want to work with them, because that alien employee is bringing some incredible skills into the workplace. And people like you, students like you have those skills. So I strongly recommend you have a very honest conversation with the employer. Now, I'm also a realistic person. The employer may say, well, I don't know. If that's the only job you have, grab it. Because if you're on a STEM OPT, maybe you can work for 1 year, keep on looking, find a new employer who will hire you and do all those immigration things for you and change your job. You're on OPT. You can change your job like that. You don't need the employer's blessing. You don't need anybody's blessing. So change your job. If they're not going to support you, if they're not going to be loyal to you, you owe them no obligation to stick around for 3 years and then have nothing left. Get the job so you're in status. Get the job so you get experience. Get the job so you have some money and support yourself. And when you get a new job that's going to support you from the immigration standpoint, say bye-bye, adios, hasta la vista, baby.
Okay, thank you so much.
You're welcome, Ainura.
Okay, next question from our colleague from our department. His name is Javad Bey. So he's asking, do people have chance to work while their education in a community college or universities or research centers without graduation? Is there a legal way that F1
Yes,
get
absolutely.
a job?
Yes, absolutely. There's two ways. There is something called CPT, Curricular Practical Training, CPT, okay? Curricular Practical Training is of two types. One is Curricular Practical Training, which is in conjunction with a course that you're taking. For example, let me give you an example. Let's say you're taking a course in mechanical engineering, and part of that course requires that you do an internship with an engineering company. That internship could be for 1 semester. It's during the course of study. You would apply for and receive curricular practical training. You're going to not be spending that semester at the university. You're going to be spending the semester working off campus at the company that will give you the necessary experience and fulfill the requirements for that particular course, your practical training course. That could be under CPT. The other way you get CPT is during the months when there is no school in session. So for example, summertime, you go to your a student advisor and you say, I have a job lined up for me. It's in my field of study, and I want to take this job only over the summer. It's a full-time job. And at the end of summer, I will be back into the school setting. And you can get your CPT for that limited 2 or 3 month period of time. So yes, you can certainly get CPT during your course of study, legally work in the US. However, limitations on CPT. You can't get CPT for the first 9 months of being an F1 student. And secondly, if you take 1 year or more of CPT, be very careful, students. If you take 1 year or more of CPT, you could lose all your OPT, which you don't want to do. So be super careful how much CPT you're getting. Don't get addicted to CPT and take too much CPT and then not have your OPT. Make sense?
Okay, so you can, yeah, so you can have only 1 year of OPT, right?
Total 1 year of CPT.
Oh, yes, CPT. I mean.
OPT is post-graduation. That is 1 year if you are a non-STEM degree, or 3 years if you have a STEM degree. And that 3 years is 1 year initial and a 2 year extension. So total of 3 years for STEM degree holders. You understand, Ainura?
Yeah, I know. I just I said the wrong. I meant CPT. Yeah.
Okay. Does that make sense to you all who are listening?
I think Laura might have a question related to that. Have your question, has it been answered, Laura?
Yes. I think like I was kind of like asking like how many like times can I use the CPT, but I think they said like
CPT you can use. Look, Laura, which country are you from?
Colombia.
Colombia. Okay. Bienvenido a Kent State University.
Gracias.
Okay. Laura, you can break up your CPT, curricular practical training, during the entire duration of your student status.
Okay.
Except for the first 9 months.
Mm-hmm.
Let's say you came from Colombia in fall of 2019, okay? You've been here till May of 2020. That's 9 months. You can start working on CPT in the summertime for an employer for 2 or 3 months until school reopens in September.
Mm-hmm.
Okay, I'm assuming now no COVID, okay? I'm just giving you an example, okay?
Yes.
Then let's say in the Christmas break, your employer says, Laura, you've done wonderful work. I need you back. Can you come back for just even a 1 month in December? So you start on December 19th after school is over, or December 15th, you go all the way to January 15th, right before school reopens, you stop your work. That's another month. You can keep on adding up your CPT as long as you don't exceed 1 year. And my clients don't even get close to a year. Stop at 11 months. Don't be greedy.
Okay.
Don't be greedy. And then you'll have your whole year of OPT after you graduate. And what program are you in, Laura?
No, I'm not a STEM. I'm political science as well.
Okay, so you're a soft science. I'm sorry, you get only 1 year, as you know, right? Only
yeah, OPT is 1 year, and then
Correct.
can you stand it for 1 more year?
Nope.
Just
If
1 year.
you are
Okay.
a soft science, if you're not a STEM degree, science, technology, engineering, or mathematics, you cannot get an extension.
All right.
Sorry. So
That's
use your
fine.
time very wisely and carefully.
All right.
Okay.
One
Also,
more question before you close on this topic. The CTP.
CPT.
Right. Has to be related to like your
Field of
field.
study, absolutely, yes.
Okay.
You can't be political science and saying, I'm going to get CPT getting manager training at a McDonald's. Flip burgers has nothing to do with political science.
All right.
Okay. Now,
Yes.
one final word on the CPT OPT issue. Please be careful, students, to make sure that you apply within the window for applications. Those things are taking so long now with USCIS. For example, if you have a job lined up, you're better off applying for your OPT before you graduate so that you get your EAD card as soon as possible after you graduate, so you don't miss that valuable time for your employment.
Awesome.
Okay.
Thank you for your information.
You're very welcome, Laura. If you have any questions, you can always contact us offline. Okay.
Thank you.
Ainur, what's next?
Thank you. Yes. So next, it's a question from Manas. I am a PhD student on F1 visa. Expires next May, but my I-20 is valid until May 2022. I will be graduating in fall 2021, but owing to COVID, I'm not in a situation to go back to India and renew my visa. How does that affect my OPT application around my graduation? In short, I am trying.
Oh, I'm so sorry. I'm so sorry. Ainur, please go on. Forgive me. I thought you were done. Ainur,
It's okay. In short, I am trying to understand if I can apply for OPT and expired visa, but a valid I-20.
Is that it? That's it, Ainur?
Yes.
Okay, thank you.
Yes, that's it.
Earlier, I thought you were done. Forgive me. Students, here's the issue between status and your visa. Your visa is only an entry document. It has to be valid at the time you enter the United States. If your visa expires, it's fine, as long as you have valid status in the USA. So there's a distinction between visa and status. Visa is just to enter, status is to stay. If your status expires, then you're in trouble. But your status doesn't expire if you have a valid I-20, you're taking classes full time, or you are on your CPT or OPT. So don't worry about that situation about your visa. You don't have to go back to anywhere to extend your visa. Your visa got you here. You entered legally, you're here legally, you're doing everything legally, you are in status. Only if you leave and go back to your home country will you need a new visa to re-enter. And right now with COVID, no one's traveling anywhere. So please be careful, stay safe in the USA, and you're okay. Ainur.
Okay, good. Thank you. So next one is, it's a private question. My spouse is under F2 visa.
I'm sorry to interrupt you. Ainur, forgive me.
Yes.
I'll have to adjourn in about 5 minutes more. It's 7:25 now. I've had great fun. Maybe we have time for just maybe 1 or 2 short questions, okay?
I think we have just about 2 questions more. So
perfect.
Yeah.
Let's take care of them. Ainur, go ahead.
Okay. So my spouse is under F2 visa. She recently got registered nurse license and got a job offer from an employer. As the immigration lawyers, can we contact our own immigrants to file EB3 visa and then a green card?
Well, again, that's such a specific question based on a specific case. I will not answer it in this forum because it's not a general question. I don't know enough about that case to advise on that issue. There's so many parameters I don't know about. I can't give you that advice. I'm sorry. I'll have to decline that question.
Okay, thank you. So I think, yeah, I don't think we have any.
I have one last question.
Everybody just
so the last question I have is that can entering the green card lottery jeopardize the legal status of a non-immigrant who is in the US under a non-immigrant visa, be it F1, H1?
That's a great question. You know, I would say to you, yes, because it exhibits immigrant intent. Okay, and one of the key parameters of getting a non-immigrant visa is that you have to show 2 things. Number 1, you have to show enough money in the USA or a way that you will respect your status and not violate your status. And number 2, you have to show that you have non-immigrant intent. Meaning, if you are going to get a visa, you're not going to remain in the USA permanently. And the burden is on us, meaning the applicant, to show that he or she does not have immigrant intent. But if you apply for a visa lottery, which is one of the 55,000 diversity visas available annually, what are you doing? You're saying to the US government, I want to stay in the USA. Give me a green card. If you've done that, you've now demonstrated immigrant intent. Could you be denied a visa because of this? Yes, you could, because in my opinion, it is immigrant intent. All right. So any other questions, Ainur or Max? I appreciate that. It's now 7:27. I'm happy to take 2 minutes more if you want to wrap up with some general remarks.
Yeah, thank you so much. I don't know if there are no other questions, then I'll just go ahead and wrap up the session for today. So are there any questions?
No, I don't think any more questions. Thank you so much for answering questions. Very informative.
You're very welcome. And all I can say to you all is good luck to you all in your studies. Good luck to all of you in your job hunting, which I know is always very nerve-wracking. And good luck to you and your families, especially families overseas with COVID. I know that's also on your minds. I hope that all of you are safe, that you're taking precautions, that you're social distancing, that you're wearing masks, that you're not doing anything that would put you and your loved ones or your friends and people you know and don't know at risk. So just be careful. These are difficult times. We're going through a difficult transition in this country, but hopefully once all this is over, and as they say, there's the expression, as the dust settles, once the dust settles, ladies and gentlemen, students, I hope that we will have a wonderful, peaceful, great nation that we will all be happy to call home, whether it's temporary or whether it's permanent. As Dorothy says in The Wizard of Oz, there's no place like home. Let's make the United States our home, whether it's permanent or temporary. Let's make it a great place. So thanks for having me, Max. Thanks for having me, Ainur. It's been a real pleasure to be here. And if you need any follow-up, please shoot me an email and I'll be happy to try to answer them as much as I can.
All right. Thank you so much once again
evening.
for this informative session. So I'll go ahead and forward your presentation PowerPoint to anyone on this list. And we would like to thank you once again for being with us today. It's been just an amazing session. And as you just mentioned, if anyone still has questions regarding their immigration status, they can always contact you through your email, and they would also see that email on the PowerPoint presentation I forward to them. So I would thank everyone for coming today, and have a very good night.
Thank you all very much. Thank you, Ainur. Thank you, Max, for moderating. Have a good night, everyone. Bye.
Bye. Thank you.
Thank you too. Bye-bye. Thank you.